Good morning, Mr. Ali.
Good morning, Chief Justice.
Did I pronounce your name correctly?
Ali is correct.
Ali, all right.
I have cousins that say Ali, but I'm Ali.
Okay. I always worry. I don't like it when people mangle my name, which is the bane of African names. I see that you and I share a birth date, and I mentioned this because not many people are born. Well, I don't know. Maybe you're the third person I've come across who was born on that particular day. So I'm excited about that. Are you well?
Nervous,
Nervous,
Chief Justice.
but comfortable enough to
Yes.
start with the interview?
Yes.
All right, let's get to it then. You hold 2 degrees. You did a BA, then did an LLB.
That is correct, Chief Justice.
The BA at the University of the Western Cape.
That is correct, Chief
Then
Justice.
you went to Rhodes.
That is correct, Chief Justice.
You started out as a teacher.
Chief Justice, if you recall, in those days, we had bursaries, and in some way you had to pay back the bursary. My BA had teaching subjects, so I was able to teach as a category C, and then I returned to Rhodes to complete my LLB.
Oh, I see. What subjects did you teach?
Science, biology, and then the whole school vocational guidance.
Oh.
Because one of my majors at UWC was psychology.
All right. So you did that for 2 years?
That was from
1984?
84 to 86, so 3 years.
No, 3 years.
Yeah.
And you then decided to pick it up and become an advocate.
Yes, I returned to complete the LLB, which I completed, and then admitted in August of 89.
Okay. What did you practice as an advocate? Your questionnaire does not state. Sorry?
Gqeberha, formerly
Port Elizabeth. All
yes.
Right. For 7 years.
Yes.
Then you left, and well, the Department of Education called you back.
Yes, Chief Justice.
And you worked there as a legal advisor for how long?
I left in 2001, so that is more or less 4 years, Chief Justice.
And then you left the Department of Education and joined the Secret Service.
Yes. As a legal advisor, and then later on a director in one of the departments.
And you remained there for 11 years.
Yes, because I returned to the bar in 2012.
In 2012.
Yes.
Yeah, and you are still there to date.
Yes.
Where? Here in Johannesburg?
Yes, Chief
All
Justice.
Right. You mentioned in your application form that your practice centers mostly around personal injury law.
That was here in Johannesburg. Personal injury as well as public, in the sense of claims against the Minister of Police, where I acted for the state attorney.
Yeah. And you state that you have not done any administrative law work that involves administrative law, constitutional law, And the only areas of civil law you've worked in is divorce and personal injury law.
That is
That
correct.
is the case.
I do indicate later in the documentation that I dealt with those matters as an acting judge.
Yes,
But
yes, you
yes.
do. All right. You've acted intermittently since 2020, you say,
That is correct, Chief Justice.
and for how long do you total up those stints to?
It appears to be around 61 weeks.
And you've written judgments.
That is correct, Chief Justice.
Any idea how many those could be?
Chief Justice, it could be because of the nature of the proceedings that I presided over, it could be over 20,
Any reported?
none reported.
Okay. Well, I'll leave it to Judge President Mlambo to flesh out what kind of work you have done during your acting stints. What I want to ask you about are the reserve judgments you list in your application form. Have you delivered them yet?
But not all, Chief Justice.
Which ones have not been delivered?
The
You list them at page 15 of the bundle. Although one of the professional bodies says they found more, 3 more to
Yes.
add to your list.
The ones that are there now, Chief Justice, is at page 15 at 9.5. The one still outstanding is the one of Alexander.
Sorry, which one?
The first one,
The first one.
yes,
All right. The others have been delivered.
yes.
Okay. That judgment was reserved on 10 July last year. What has been going on there?
Yes, Chief Justice, this is one that has had me busy, and I'm trying to my best to deliver it, and I know I've said previously it will be delivered this time, that time, that time. But it must be done and will be done, Chief Justice.
When do you hope to have it delivered?
Well, finally, it must be done by the end of this month.
The end of October.
Yes. If it's if it's sooner, the better.
Yes. The worrisome thing, Advocate Ali, is that all these reserve judgments were reserved months ago. Well, when did you deliver Foster and Lebitze, which were reserved in August and October 2023?
Recently, Chief Justice, the dates I can't give you.
No, it's
At the
fine. But
moment.
you say recent. How
Yeah.
recent?
It could be 2 months ago.
About 2 months ago.
Yes. But it was after the submission of the application.
Then the remaining 3 on your list were reserved in February, which is several months ago. Were they also delivered about 2 months ago?
I would think so, Chief Justice.
Yeah. Well, the general counsel of the bar reports that they found at least 9 outstanding judgments. So which are the other 3? Well, they say at least 9. They don't say 9, so there could be more. But let's focus ourselves on the three, the extra three. They specifically mention. Which judgments are those?
Chief Justice, I can't off the top of my head remember which ones those are in respect of, I thought the documentation of the General Bar Council would have been here, and I thought they would have but the ones, as I understood their comments and objections, it had to do with the length of time, as you have already also expressed, Chief Justice. But off the top of my head, I can't think of the other three.
Do you deny that there are more than the 6 you have listed? This is what I'm concerned about.
Oh, no, I don't.
You don't?
No.
But are you working on them?
Yes, Chief Justice.
This is extremely worrisome, Advocate Ali. You would be aware of the existence of norms and standards that enjoin judges to deliver judgments within 3 months of the hearing of the relevant matter, and certainly no later than 6 months from the hearing of the matter. And
Yes,
here you are, you have a whole pile of late judgments, some over a year, by over a year. And now we have professional bodies. In fact, I want your comment to what the GCB, which I assume you remember of, it says it would send an acceptable message to the public at large if you are appointed. What would you say to that?
Chief
And
Justice.
they point out that the ability to deliver judgments expeditiously lies at the heart of dispensing justice.
Yes. Chief Justice, all I can indicate, I acknowledge, because it's factual what they say in terms of the delivery. All I can indicate is that it will be my endeavor, and it must be, that the judgments get delivered within the norms and standards policy.
What has been your challenge? Why have you delayed these judgments?
Chief Justice, in some instances it would have been, but it wouldn't have been that long. This is why I in some instances it was an issue of ill health. In other issues, it's a matter of I type my own judgments, but to me that doesn't really necessarily explain away the fact of the lateness of the judgments, Chief Justice.
And what guarantee does the judiciary have that if you are appointed, you will not continue on this track?
Chief Justice, I can today then express myself to say that I would. And furthermore, the JP is a hard taskmaster in respect of matters of this nature.
Well, he has not been able to crack the whip hard enough, because here we are, hard taskmaster as he may be.
Yes, I accept that.
All right. Thank you, Advocate Ali. I'll hand over to JP Mlambo.
Thank you, Chief Justice.
Thank you, Chief
Questions to you.
Justice. Good morning, Advocate Ali.
Good morning, JP.
Thank you for availing yourself. I just want to touch on a few issues. Let's start first with your exposure and familiarity to the work in the Gauteng division. You've admitted you've acted for a period of 61 weeks totally.
Yes, JP.
And in that time, according to the spreadsheet in front of us, you've done 7 weeks in the opposed motion court.
Yes,
And you would agree with me that that's one of the areas where judges accumulate reserve judgments.
that is correct, JP.
Because in a week, if you are in that role, you are lucky if you get less than 12 opposed motion matters for that week.
That is correct,
Right.
JP.
The other area where you would generate reserve judgment is the special motion role. There, you've done 2 weeks there.
Yes,
That's also, in fact, it's the most difficult because that has the most complex opposed motions, isn't it?
yes, JP.
Yeah. And then the other area, I see you've done 2 weeks of urgent court.
Yes, JP.
Yeah, and I can tell you and the commission, well, you know it. I don't easily put acting judges in the urgent court week because the Gauteng urgent court week, you need to smoke something to be allocated there.
Yes, JP.
Right. But I think, to be honest with you and the commission, having done 61 weeks, one would have expected you to do more work in that role, because you would have got familiar with the work of the division, seeing that you only were allocated to the last year to the urgent court week, having acted since 2020. But the fact that it's only 2 weeks should be something that you need to explain. I know I do the allocations, but as I say, I've explained to you that I need to have the confidence that the acting judge will deal with the work if I put them there.
JP,
Yeah.
the issue of the urgent court, as you say, you do the allocations, and in 2022, 2023, and this year, I think I started the urgent court last year and again this year. So
Yeah.
that's the 2 weeks.
Yeah.
I am available and I have been available. So I can't really answer it differently,
Yes.
but to say that I am available.
Yes.
Whether because your question somehow seems that you indicate you want to be confident in the people you put there. So I was of the view that that I would get more,
Yes.
but I didn't.
No, I'm not blaming you. I'm just saying it's my confidence, and I think partly the issues the CJ raised with you
Yes.
informed my decision why. Because
Understood.
in a normal urgent court week alone, there's 2 judges there alone. You are lucky to get less than 30 opposed urgent motions that week. Am I correct?
Correct.
Yeah. So it's a heavy work area.
Correct, JP.
Right. Now, that's the exposure you've had. So I want to tell you now, I have my own scoring metrics as to how I score candidates. So the allocations themselves and the work you've done I also will have to score you, but it will be informed by the number of weeks you've done in each particular week, especially the difficult work areas. You understand that?
Yes, Jay.
I want you to know that. Right? Now, let's come to the judgment you've written. You've listed 16 judgments. Check the list there in front of you.
Yes.
The reason I'm mentioning this is someone because we've got some of your competitors today who've acted probably half of the time you've acted, who've written a lot more judgments than that. Are you not shortchanging yourself here? I mean, you've acted for 61 weeks. You've done 7 weeks in the opposed motion court. That's a lot of work. Where are the other judgments?
Yes. JP, if I can just explain.
Yeah.
There are more than these judgments.
Yes.
There was a computer crash, my own. And you will recall in 2020,
Yes.
the case lines hadn't really started
In
2020. When
started.
at the beginning of 2020, some matters were on case lines and
Yes.
others not.
Yes.
And so when I was going through the judgments that should have been somewhere, you wouldn't find them on case lines.
Yes.
Because they weren't uploaded on case lines and we would have had the files. Same with opposed motion court in 2020. I would have had the files with me rather than on case lines. And what did help us post or during March is that, if I'm not sure, there was a directive that all matters would be on case lines. This is during the COVID period,
Yes.
which assisted us greatly.
Yeah. Okay. Look, I understand your explanation, but we give you a bench book, don't you?
Yes,
We give you a bench book, and that's where you record all the matters you hear. And if the matters were done in paper form, your bench book is the first go-to source to check which matters did I hear, where's the judgment, isn't it?
yes, JP.
Yes.
I must indicate, in my first stint,
Yes.
I didn't take my bench book with me.
Okay. Okay. Now, let's come to your judgments. The CJ has already traversed that area. You know that my division is the first one to have had judges being disciplined for failure to reserve judgment. Do you agree with me that that is the overall primary existential basis for a judge to decide the matters that come before them?
I agree with you, JP.
Yeah. So, don't you think, I think, let's just debate this. You are here, and I've actually been open-handed and give you acting stint. Do you think you could benefit some more if you are given more acting time, and then to see if these judgments that keep on cropping up and taking long to come out becomes a thing of the past?
Yes and no, if I can
Yes.
put it that way,
Yes.
JP. I'm not 50 anymore, and time is moving on.
Yes.
It is so that more time will be beneficial,
Yeah.
but that time as a judge also would be, and as I've indicated to the Chief Justice, that if given the opportunity,
Yeah,
there would be great improvement in that area.
yeah, yeah. So, as I indicated to you, I have my own scoring matrix that looks at particular areas. It's four areas. One is about judgments, one is about exposure, those two. If I were to ask you sitting there, your performance in reserving judgments and in handing down judgments, out of 5, how much would you score yourself?
2.5.
2.5. Okay. Well, thank you very much. CJ, I'm done. Thank you.
Thank you, JP. I'm sorry, in the rush to start the proceedings, I forgot to welcome Judge President Tlaletsi, who represents the heads of court in Judge President Mlambo's place this morning, and Premier Lesufi, Gauteng Premier, who is here to make sure that we don't bring back judges to his courts. Good morning and welcome, JP and Premier. Premier, on that note, do you have any questions for the candidate?
Thank you so much, CJ. Truly appreciate. Thank you. Let me also greet fellow commissioners. Good morning, Advocate Ali.
Good morning, Premier.
Thanks. Just to belabor the point of allocating yourself 2.5 on outstanding judgment, is it lack of capacity or it's lack of support?
Definitely not capacity, because capacity would mean that you are unable to come to, my understanding of, you are unable to come to grips with the matter that is before you. The support part is, as I indicated to the Chief Justice, is one of the areas, but shouldn't be the main area of justification.
Question is, I saw when you listed your experience and background in legal matters, you literally listed everything rather than the part of support that you're providing in the South African Secret Service. I assume it was also related to legal work, but I wonder why you didn't list it as part of the work that you've done that is related to law or legal work.
It's probably but it is contained in my CV. I'm not sure why at the present time I didn't list it then. But I did do legal work at the Secret Service also.
Thanks so much, CJ. Thanks.
Do you have questions, colleagues? JP Tlaletsi?
Thank you, Chief Justice. Mr. Early, I just want some clarification from the answer that you gave to the Chief Justice regarding the fact that the GCB seemed to have picked up more judgments outstanding than you disclosed. And the answer you gave is that you do not deny that, but you cannot remember them on top of your head. But later you said that you are working on them. Is that a fair understanding of what you said? And if that is the case, would you kindly explain that?
I thank you, JP Tlaletsi. When the question was posed, I said I do not deny it, and I said I am working on them. The two don't seem to marry when I think of it, you having posed the question.
I see. Thank you.
Yes, no.
Continue, sorry.
What I was meaning, if I had sight of them now, I could tell you they actually have been delivered or they haven't been delivered. And therefore I would be working on them. That's the best way I could explain it.
I see. And then my second question is, there is this problem of practitioners who are acting both in the high courts and the magistrates court, not delivering judgments either timeously or at all. Now, if you remove yourself from the fact that you could be one of those and look at things objectively, what advice would you give us to the heads of court and the JSC as to how to deal with this problem?
I think the issue has already started in the sense that my JP has started the ball rolling in respect of issues of this nature. And the more that one implements the policy, I would believe that down the line you'd get less and less deficiencies.
Do you see the LPC having any role to play in this regard, and what role can it play?
I'm not sure how, although the LPC can play a role when matters of that nature are reported to them. If memory serves me right, where acting judges are remiss or misconduct themselves, those matters would be reported to the LPC.
I see. Well, I'm asking this also because you'll find that practitioners owe judgments, but they appear almost on a daily basis before the same courts in which they owe judgments, be it in the lower courts and the high court. And if I follow up on the suggestion that given a further acting stint would resolve the problem, will that not be tantamount to rewarding someone who's not able to deliver?
JP, it's not, you give the person the chance, and further acting stint presents itself to improve that particular person. And that's the best way I would answer it.
And would you agree that you should also balance that against the interest of the litigants and the public in general?
Absolutely.
Whether not to expose them to such a situation.
Absolutely.
And make them guinea pigs in that regard.
I agree.
Thank you, Chief Justice. Thank you, Mr. Ali.
Thank you, JP. The DP's one.
Thank you, Chief Justice. Good morning, Advocate Ali.
Good morning, Commissioner.
I've just gone through your questionnaire. And more especially, I just want to refer you to page 9 of the paginated bundle. It's a section dealing with the court experience. Now, based on the information that we have provided in this questionnaire, surely it's difficult for one to assess your suitability, whether we could, at the conclusion of this session, recommend you. I'm not sure if, based on the information that you have provided, because you are marketing yourself, you should have given us more information that will sort of guide us in interviewing you. Would you agree with that statement?
I agree.
The other thing that concerns me, paragraph 6.2.4, labor law experience. You said as an assessor, in the labor appeal court, I've sat in that court on a number of occasions, and we have never used the assessors. Where does it come from?
In the Eastern Cape, the Labor Appeal Court, if I could, I'm not sure of its citing. I was, Judge Kruan invited myself and Professor Grogan to assist in the appeal. I called it assessor because at the time, I was an assessor in the criminal courts and I was invited to assist Judge Kruan in one of the appeal matters he was dealing with.
Now, I'm not aware of that practice because we would do Johannesburg, Cape Town, Durban. I also did labor appeal court cases. I also sat on the labor appeal court cases in the Eastern Cape. So we have never used the assessor.
JP, I'm not sure whether the term could be described as correct, but I did preside with Judge Kruan. And this would have been around about 93, 94.
Unless maybe it was an industrial court, but not the labor court. Thank you. No further
Thank you.
question.
Thank you.
CJ.
Minister.
Thank you, CJ. Good morning, fellow commissioners, and good morning, Advocate Ali.
Good morning, Minister.
Thank you very much. I know CJ touched on the issues of outstanding judgments. I'm just finding it hard to be convinced on how you will improve given the reviews that have been outstanding and how you have handled them previously. It doesn't suffice to me to say I will definitely do them better. What is the plan that you have? I mean, for example, in the case of Alexandra, the one you say is still outstanding. It's a very painful matter, actually. It involves a minor child, and there's a long history in when the matter said 3 times you have set deadlines for yourself. Even at the intervention of the Deputy Judge President, you committed that you will give a judgment on the 29th of March. You did not meet that deadline. The Office of the Deputy Judge President tried to intervene, and you undertook to finalize the same judgment on the 22nd of April 2024, which is a month later from the first commitment you made. You also did not meet that. And then the matter was escalated to the Judge President himself on the 3rd of July 2024. And you addressed the letters to the parties who are the attorneys and the family, the complainant, on behalf of the minor child. And you said the judgment will be dealt with on the 5th of July 2024. You are apologizing. You still did not meet this deadline. And today we are in October. We are still without this judgment, and you are saying to the commissioners here, you will improve on this matter. I think really right up to the office of the judge president, including the deputy judge president, this matter should have been resolved by now. At least it should have been finalized from your side. Do you have any comment there?
I can't comment further than what I have indicated, Minister. And I indicated to the Chief Justice when I would be finalizing, and I understand the frustration with that statement, taking into account what you have just read out. And I cannot put it any further than what I have, Minister.
So would you agree with me if I really question your commitment to the rule of law on the basis of all these chances you have been given? Look, this is a minor child with cerebral palsy. Rightly or wrongly, whether the case that has been put forth for the payment for future medical expenses. So a legitimate question will be, currently, what is the state of this child if we are unable to assist, at least from the handing down of the judgment? Do you think you have acted to the best of your ability in this matter, at least in trying to give justice to the minor child?
Minister, I don't want to justify the issue regarding when it will be delivered. In this matter, it's one that is somewhat different. There are matters that have been dealt with, and the ones that are outstanding now is dealing with the issue of the public health defense and so forth. So there are other medical expenses, and if I remember correctly, the hospital itself is providing, and the child still goes to that. But that doesn't take away the issue, Minister.
Thank you, Minister. You may ask a follow-up question.
Just to end this quickly, who nominated you? Who nominated you for as a candidate?
I nominated myself.
Who accepted the nomination?
I just nominated.
You nominate? Okay.
I really don't.
No. Okay. Let me assist you this way. You nominated yourself, and then you accepted your own nomination. So, what is it that the advert requires that persons must be nominated? Did you read the advert?
Yes.
Does it not require that a person must be nominated for the position, rather than persons nominating themselves?
I'm not going to debate it, because the nomination doesn't say by whom.
No, I just want
But it is what it is, as it's there, and I can't take it any further than that.
no, just so that we don't go further with your interview. Look, correct yourself, correct me if I'm wrong. You are not supposed to be here because you have not been nominated. You are not supposed to even be here. Thank you, Chief Justice. I think at this stage we should end with your interview, but you can convince me. That's what I'm going to argue, that you are not supposed to be here.
Chief Justice, all I can say is I applied, there was the nomination, I was shortlisted, and that is why I'm here. I cannot say I'm not coming.
Yeah, the question is how, how did you get shortlisted?
Unfortunately, Chief Justice, I'm not in charge of that particular process. And I think it's a bit unfair.
No,
For-
I have no quibble with that. I'm not expecting you to answer that question. You did not shortlist yourself.
Yes.
But I'm just quipping myself because I did look at your nomination and I did, because there's a consent. You nominate yourself, then you consent to the nomination. That's what I did not look closely at this because I saw your consent. And I completely missed that you were consenting to your own nomination of yourself. That's quite bizarre, to say the least. And anyway. Okay, Commissioner Kunyan, your hand was up first.
Good morning, Chief Justice. Good morning, fellow commissioners. Morning, Council Ali.
Morning, Commissioner.
Mine is one question only. You know for a fact, as Council, of the often quoted expression, justice denied, delayed is justice denied. Just for a second, remove yourself from that chair and put yourself in my chair. Would you be justified to recommend to the President the appointment of a person who has delayed justice, in dispensing justice, who has delayed dispensing justice for over a year? Would you do that? Would I be justified to do that?
Commissioner, it's difficult for me as the candidate to answer you regarding your prerogative. What I can indicate to you only is that on the objective facts before you, you will make your decision as to whether I am worthy of appointment to a permanent post as a judge.
Thank you, TJ.
I'm not happy with that answer, Advocate Ali. One of the hallmarks of a judge is impartiality. You should be able to divorce yourself from the fact that you are a candidate and give an honest answer to the question. You should be able to do that. And I'd like you to answer Commissioner Nkonyena's question honestly.
Chief Justice, what I was trying to impart was that there are judgments here and there are other judgments which obviously are not before you, which have been delivered on time. And I'm saying one must have a holistic view on what that particular candidate has done. Rightly so, there are those judgments which are factually correct, that they have been reserved for a long time, but there are others that have been delivered on time. And hence I was saying that one would look objectively and say, do you penalize for the whole or only for the part?
Chief Justice, perhaps to help, can you answer my question yes or no? That's it. That's what I want. I heard your explanation, and you have tried to explain before. All I want, would you do it yes or no? That's it.
Chief Justice, I find it difficult to answer the question yes or no, having given an explanation. You asked me to explain, and I
It's all right if
explained.
you're struggling with doing what he's asking of you. We can move on. Commissioner Lekhanyan?
No, Chief Justice, just to make a follow-up on the questions that were asked by Commissioner Simelan, Commissioner Minister, and Commissioner Premier. I want to refer you to Section 28 of the Constitution, which is contained in the Bill of Rights, which speaks on the rights of children and related national legislation. And you can also include other international conventions. Where you stand as a candidate, do you think that what the minister asked you about a minor who has a specific health condition, doesn't that constitute a violation of the rights of children or substantial injustice on the part of that child? Having delayed that judgment for over a year, what is your judgment on that matter? If we have to make a judgment on your failure, what becomes your judgment? Doesn't that constitute gross violation or substantial injustice?
I can indicate to you, Commissioner, as I indicated to the Minister, the nuance in respect of this case. And I would answer yes and no to your question.
Your answer is yes and no.
Yes, because of the explanation.
Okay. Let's leave it there. If you were one of the drafters of the Constitution of the Republic of South Africa, why would you think that the drafters allocated themselves ample time to decide that the rights of children must be included in the Constitution?
Commissioner, the rights of the children being included in the Constitution speaks to the vulnerability of that of those or that section of the population, and needs protection.
Okay. The last will be what Commissioner Lesufi has asked, whether the problem on your part is with regard to capacity or lack of support. And you have been asked several times here, you are unable to come clearly before this commission to say, I have 20 outstanding judgments and I'm planning to deliver 16 of them on the following days or in this period. And the remaining number will be delivered in the period that will follow. You have been very dithering and very reluctant to respond to this question. Just to give the exact, a judge, remember, a judge is not an ordinary person in society. You cannot behave yourself like a person who has not seen the inside of a book. You have to be very honest with us if you think that you are a fit and proper person for these positions that have been advertised to. Tell the Chief Justice or the JP, who are your supervisors? How many outstanding judgments are there? And what is your plan to deal with them? If you can't account to your supervisors, must we call you before Parliament to come and account before Parliament? When your immediate supervisors are here, they want answers from you. Why aren't you giving them those answers? How many outstanding judgments do you have, and what is your plan to deliver them?
Commissioner, when answering the Chief Justice in relation to the one matter, I indicated when I would be doing that. In respect of the others, which I indicated off the top of my head, I don't have, I can't indicate to you the number off the top of my head. But I indicated to the Chief Justice that I am working on them. And in respect of your specific question as to when those would be delivered, I would indicate the timeline of end of November.
No, I did not want to be hard with you earlier, but I have to mention to you that from my experience, and I know that I speak for all judges, nothing is as heavy, as burdensome as a reserve judgment. It haunts you until you have delivered it. It is extremely worrisome that you can't even remember. You say you are working on them, but you don't have any detail. You can't remember. You can't give us any detail on these judgments you're supposedly writing now. I find that strange. I find that very, very strange. Do you have a comment?
Chief Justice, as I indicated, the ones that were in here, that the one is outstanding in the
Yes,
questionnaire.
you have, and you've given an undertaking to deliver it by the end of October. But we're talking about this, the at least 3 that the General Counsel of the Bar has mentioned.
And what I was indicating to you, Chief Justice, is at present I don't see the judgments that they're indicating, and I'm indicating that they could have been delivered already, but that was my only reservation with the 3 that you had mentioned that the General Counsel of the Bar had mentioned.
But then you had said you don't deny that there are such outstanding judgments, that is the problem.
Yes, Chief Justice.
So what do you mean you don't deny that there are such outstanding judgments, and then in the same breath they could have been delivered?
Yes, I understand. I should just remain with my answer that
Which is?
which I had given you previously, that I am working on them. Because you can't have both answers.
All right. Commissioner Hassan? Where did she go? Any questions? Commissioner Gotzel.
Thank you, Chief Justice. Good morning, Advocate Ali.
Good morning, Commissioner.
With reference to news reports that civil claims in Gauteng's courts might only be heard in 2028, it was recently reported that legal professionals are at their wits' end over the longest backlog in history. Now, in your view, what is a judge's role in ensuring expedience in the administration of justice? And I don't want you to go back to reserve judgments. This is a general question.
The statement of the backlog, in my view, doesn't speak to the expedience of the court, because the expedience of the court is about how many matters come before that particular division. And are you able to have your matter heard? That is one issue completely, and which is different from the judgments that are reserved after the matters have been heard. As I see it, the backlog is that claimants or litigants are not able to get to court because of the backlog. Not that they have not had judgments on matters. I'm not sure if I explained the issue, because when you read out the backlog, then you asked about the expediency.
No,
Leaving out reserve judgments, you said.
yeah, and I think you misunderstand me. My question is, what is a judge's role in ensuring the expedience in the administration of judges? I understand what you're saying, but there are obviously many factors that contribute to a delayed court roll. But what could you do as a judge to assist that problem?
Well, I know in the Gauteng division, in Johannesburg and Pretoria, there's meetings upon meetings regarding how we can get the backlog down. And I think the JP answered in the media also that we have pro bono counsel and attorneys that have been taking it upon themselves to make themselves available so that matters can be cleared. And I think that is a good initiative.
Thank you.
Are there any questions from the virtual platform?
Thank you very much, CJ. Good morning, Advocate Ali.
Good morning, Commissioner.
I want to traverse a different line of questioning with you. As you know, that Gauteng is the place where usually the state will be sued, and some of the state departments will be sued on the basis of administrative law. I just want to ask you this question. Should you be successful, you will be expected to have a good grasp of administrative law generally. My question to you is, can an organ of state utilize the provisions or utilize PAJA generally for the purposes of reviewing and setting aside its own decision?
Can you just repeat the last part? I think there was a distortion at the end.
All right, let me repeat the whole thing. Can an organ of state utilize the provisions of PAJA for the purposes of reviewing and setting aside its own decision.
My answer would be yes, that they would approach the court to have a decision set aside on the basis of the unlawfulness of that decision.
No, well, the answer seems to be contrary to what the Constitutional Court said in State Information Technology. Let me ask a different question. What is the difference, if any, between a review process under PAJA and a review process under the principle of legality?
The review process under PAJA is dealt with in terms of Section 6, memory serves me right, and deals with the processes that would be against the administration of justice. The issue of legality is dealt with more constitutionally in terms of what decision has been taken, whether that particular person has traversed the rule of law in coming to that decision.
Well, I have difficulty understanding that, Advocate Ali, but I will leave it there, CJ. Thank you very much.
Thank you, Prof. Thank you very much, Advocate Ali. We've reached the end of your interview.
Thank you, Chief Justice.
Good morning, Prof.
Good morning, Chief Justice.
How are you?
I said this morning to my husband, I'm appropriately nervous for the importance of this day, but I'm very happy and honored to be here. Thank you.
Good. It's good to have those butterflies. They keep you on your toes. You hold 3 degrees from Stellenbosch, BA International Studies,
That's right.
and LLB,
Yes.
and an LLD
That's right.
on expropriation of property under the South African Constitution.
Yes, compensation for expropriation under the
Yes.
Constitution, yes.
And you say your doctoral thesis for this degree was the first extensive contribution in the country on the subject.
That's right. I thought at the time I have to finish quickly because it's going to become irrelevant. And that was not the case.
So you started out as a postdoctoral research fellow in 2009
That's correct.
at Stellenbosch.
Again, yes.
Then you worked your way up through various universities. You became a senior lecturer at UJ, associate professor at Northwest University, then professor of law, Northwest University. But there is a question I have for you. You are now a professor of law at which university?
At the University of Pretoria.
Oh, your form says University of President, and I thought there's a new
Oh dear.
university of which I'm not aware.
My CV is correct, but my form might be incorrect. I do apologize.
No, these things happen. All right. You're an academic. You've not practiced either as an attorney or advocate.
No, I have not.
But you've done a lot of work in the world of academia. You've edited books. You've contributed book chapters in various books in your area of specialty.
Yes.
Do you think, let me just ask this question at the outset, should it be a disadvantage that you have not practiced?
Chief Justice, I must say, when I started to act, I thought that the procedural part of practice would hinder me. But I think within the 49 weeks that I have acted, I have shown that I could master that. I don't think it is a hindrance for me to be appointed to the bar, to the bench, not having practice. I think actually as an academic one brings a different background to the bench to diversify the bench, and it can be of a benefit to the bench to have people from different backgrounds on the bench, especially if they have shown in 49 weeks that they are able to do the job, which I think from the feedback we have received from all the legal bodies, I have done.
Yeah.
Yes.
And during those weeks at the High Court, you've sat in a wide variety of matters.
Yes, I
and
have.
wrote judgments.
I did. I wrote 101 judgments. Well, I wrote 91. I sent an amended form yesterday to the JP just to include the 10 judgments where I sat with colleagues. Of course, I'm also the author in a sense of those judgments, so I've just included them to be complete. 101 judgments, 3 of them, I found another one reported yesterday when I've just made sure, and there should be another one on the way to be reported. I don't know where in the process it is. You might know sometimes you mark something as reportable, they send it to the publishers, and the publishers themselves decide whether it is indeed reportable, so I'm waiting still to see if there's another reported judgment. But yes, so I think I've wrote on a wide variety. I've sat in the criminal court as well for a term, so I've covered all the courts.
That is prolific.
Yes, thank you.
And you were able to produce all these judgments within
3 months.
3 months of the hearing of the matters.
Yes.
Well, I suppose that's the advantage of coming from that disciplined world.
Yes, so
writing comes naturally to you.
Yes, I had to get used to the style of writing. I see that the one comment, I think it was from the General Bar Council, is that sometimes my judgments are too long, and I take that on board. But I think as I progress through the writing, it will get better or shorter. But it definitely does come easy.
And well, I'll leave it to JP Mlambo to take you through the paces on how long you acted there and the
Yes.
kind of work you did. But I was just a bit concerned about the area of criminal law, which is very important.
Yes.
But you do say that you spent 9 weeks in the criminal court.
Yes, I acted a full term in the criminal court. I finished all my cases that were allocated to me during that term, which I think is sometimes unusual, but I had amazing counsel on both sides there, and we could ensure that we could finalize all the criminal cases in that one term. It was, as I must say, the first acting term was a 90-degree learning experience for me, and also when I went to the criminal court, that was also a great learning experience for me. But I am very great. I told the JP when he said to me, I must stand, I must make myself available. I said to him, I can only make myself available if I have done criminal work, and I was very grateful for him to put me in the criminal court for a term.
Yeah. And what kind of criminal cases did you deal with? Did you do appeals, trial?
Yes. So, of course, if you're in the criminal court and the high court, you do the matters that come before you are serious matters. So I've done all the serious matters. During that time, I did also appeals from the magistrate courts, those automatic appeals, and bail appeal I've also done, and of course then a full court appeal where I sat with 2 senior judges. Yes.
All right. And it went well.
It went very well, yes.
All right. And in the midst of all this, you are raising 4 young children.
Yes, that's great.
How do you juggle?
I must say, it's amazing children. I can spend the whole interview talking about them, but I won't. I always think back on that saying, what we say, it takes a whole village to raise a child. So I've got my village. I've got a very supportive partner. I've got people that help me at home with the children. And I think, yes, so I've managed not only acting, but also I think it might be unusual for this commission to have an academic, but just to also explain, while I act, I also have academic obligations that I have to fulfill, like postgraduate students, the chapters that I have to read, must make sure that they finalize their studies. So it is a heavy workload. But I think my village stand by me. And I've listened to your conversation yesterday. Was it with Advocate Jukela from KwaZulu-Natal? And I could really identify with what she was saying.
Yeah.
And we make it work, I think.
Yeah, look, all working mothers,
Yes.
wherever you find them, can identify with this. It's a working mother's life.
And it's an issue that I feel very strongly about, I must say, to make space for carers to also have a career.
Yeah.
Yes.
All right, thank you, Professor
Thank you.
Tigelius. I'll hand over to Judge President Mlambo to put questions to you.
Thank you very much, Chief Justice. Good morning, Prof.
Good morning, JP.
Just before I go on to the business of the day, just to deal with that part of you raising young children.
Yes.
You and I have had, I think, the 2 meetings face to face
Yes.
to look at your readiness
Yes.
and candidature.
Yes.
And in one of those meetings, I think it was the first one, when you said, it was over a year ago, when we decided that you're not ready yet, continue acting, and let's see what comes out of the wash. You remember that discussion?
Vaguely, but yes.
No, but the comment you made when I said, but you've got young children,
Yes.
you made a comment to me about the role of your husband.
Yes.
Do you remember what you said, or should I tell the commission? Because that's stuck in my head.
I hope my husband is not watching the interview, but you can
You said he was part of the deal, so he must also play mommy duties.
I'm sure I didn't say that, but I do have a very supportive husband.
Well, because he's watching, you'll deny it. Anyway, in terms of your spreadsheet, I think
Yes.
my Mine misses a week. You say 49 weeks, and I take your word for it.
Yes, this the spreadsheet. I must just bring it to your attention. Perhaps the one that I've just received is different
Yeah,
from the one that I've sent you.
yeah.
I know you don't want to believe me that in the third term of 2023 you gave me 3 urgent weeks, but you did give me 3 urgent weeks in that one term. And I do want to point that out.
Because as I say, I take your word for it. Which year and which term?
The third term of 2023.
I see. So that ups your urgent court weeks to 6?
4.
To 4.
Yes, so I did 3 in that term, and then I did 1 in the third term.
Okay. So you
Which
did
just
4
passed,
urgent weeks.
yes.
Thank you very much for that correction. And that's one of the heavy duty areas.
Yes.
You agree with that? And the norm is you don't get, because there's 2 judges there.
Yes.
We're only starting this term that we're putting 3
yes.
judges because it's quite heavy.
Yes.
But you acted when there were 2 judges, and the norm is you get something like 30 or so
Yes.
opposed agent applications to deal with. Is it?
So I didn't get quite 30. The first urgent court was during the recess.
Yes.
That was with Judge Sinyati. And I was told that was quite a calm, urgent week. I got big cases, but not many cases.
Does recess, yeah.
Yes, and then I did. Now I must remember. Then I did another urgent in Pretoria with Judge Adams. So he did the urgent in Pretoria,
During term.
and there I got about 22.
Yeah.
And then I did another urgent in Johannesburg with Judge Opperman. And I think she was taking care of me in not giving me a too heavy workload, but she gave me very interesting cases, and I think that was about 15 cases, yes.
But anyway, I think the story is, the bottom line is you were able to handle all those cases.
I was, yes.
And then my spreadsheet suggests you did 2 special motion weeks.
Yes, I did.
And those judgments, how long did they take you to produce?
So the first special motion was the first big motion case that I heard. I think that was one of the judgments that was quite lengthy because it was my first judgment that I really spent time on. That took me less than 3 months. It initially took me 2 months, and then I lost the file, and then I had to type it from the...
But it took you not more than 3
yes.
months. And then you've done 4 opposed motion weeks.
Yes.
Yeah.
5.
Is it 5? Okay,
5,
sorry,
yes.
I'm shortchanging you.
You are shortchanging me, JP.
And the full court appeals, my spreadsheet mentions 3. That should be correct.
The civil full court, mine is 2.
The civil appeals is 2. I'm talking about the full court appeals where there's 3 judges.
Yes, 2.
3.
Yes, where there are 3 judges, I did 2. I did 1 in June this year and 1 in July.
Did you scribe any of those judgments?
I scribed in the June one, I scribed 1 with Judge Wilson and Judge Crutchfield.
Yeah.
When I sent the draft, I did not receive substantive comments. It was more about style and grammar and so on.
Yeah.
That was delivered, I think, within 2 months. The July one, I sat with Judge Leepiner and Judge Bally, and again there I only received typographical type of
That's
comments.
fine. So coming to your judgments,
Yes.
you mentioned 101 that you've set in, but those that you've scribed,
Yes.
your own judgments,
91.
91, over a 49-week
Yes.
acting stint. And I see you're one of those candidates, you don't list judgments. You do now and then list leave to appeal judgments.
Yes, so
But, no, you don't have to explain anything. I'm just pointing it out to you. But looking at this list, do you confirm that none of these judgments took you longer than 3 months?
I do confirm, yes.
Right. And then the CJ touched on you doing criminal work. She asked you what type of work you did. I think you missed it because she wanted to know whether you did trials.
Oh, yes.
You did trials.
I did trials. I did, I think, 4 trials.
And you finalized all of them.
I finalized all of them before the term ended.
Let me just say this. It's quite a feat to sit in criminal trial role in Gauteng and finish the term without apartheid. Because that's why we have a backlog there.
Yes.
There are all sorts of things at play in that role.
I think I was lucky in that I, in most instances, only had 1 accused. I think the problem often comes in if you have more accused with more
Yes.
legal representatives. Yes.
So the reason you were put in criminal trial role, which a lot of people don't want to or are scared of, was to give me confidence that you can stay in my acting judge pool for the future. Remember,
Yes.
and for you to be exposed to that work area.
Yes.
Thank you.
Thank
And in addition to the trials, you also sat in appeal, criminal appeals.
Yes, I
Okay.
think, yes, I can show you where on the page.
No, you don't have to.
Okay, all right.
We don't have to. I mean, if commissioners want to confirm that with you, they will ask you.
Thank you.
So I was saying to the other candidate that I have my own scoring matrix. Out of 5, how much would you score yourself regarding reserve judgment, delivering reserve judgment? And let me tell you, if you didn't take longer than 3 months, I give you the total. If you delivered after 3 months, but not beyond 6 months, I give you 4.
Yes.
And then if the scoring reduces, the longer it takes for you to hand down judgments.
So if that's the scoring matrix, I would give myself a 5.
I see. And then in terms of exposure to complex work,
Yes.
it's also out of, that one is out of 7.
Out of 7.
How much would you score yourself? That is urgent court,
Yes.
motions, opposed motions, special motions, those 3 in particular.
I just want to say I'm somebody that's very hard on myself. So these questions, I don't know if I will answer them truthfully to myself.
No, that doesn't bind anyone. I just want, because
I
it tells
think-
us how
yes,
confident you
I
are.
think they were quite complex matters, not necessarily in terms of the law, but in terms of, for instance, I handed down a judgment about a month ago of a matter that it was an application, there was a counter application, and then there was an intervening party.
Yes.
And those things become complex, not necessarily because of the law, but because you have to concentrate to see what fits in where and what is the relief sought and what is the relief that you can grant. So I've done a few of them. I've done not a tax, I don't know if customs fall under tax, but I've done a customs, that was the one special motion that I had. I've done many insolvency type cases, which can become complex at stages. Yes, and Paja is always.
No, look, I don't want you to
Yes.
to try and justify
Oh, I
anything.
must give you a score. Sorry.
I'm giving
yeah.
it 7 because it's a heavily weighted area.
Yes.
Because that's the area where judges get reserve judgments,
Yes.
and their performance in this complex area
Yes.
tells me that they deserve a higher scoring or a lower scoring, depending on how they perform. So I'm asking you, out of 7, how much would you score yourself?
6.
6.
Yes.
Okay. Thank you very much. CJ, thank you very much.
Thank you.
Thank you, JP. Premier?
Thanks so much, CJ. I don't have questions that I need to pose to the candidate. Thank you.
Thank you.
Thank you, Premier. Judge President Tlaletse?
Oh, thank you.
Thank you, Professor.
Thank you.
I have looked at your rich experience in the academic field,
Yes.
and it's quite impressive.
Thank you.
And just want to get it from you, to understand from you. Given that you have gone through acting stints in the High Court, would you say they were quite beneficial for the person in your position to go through these ranks to gain the relevant practical experience and have the feel of adjudicating cases in the actual court. And rather than seeing yourself as, given my experience, I'd rather go to the Constitutional Court as an example. And if you've got anything to say about that, I would ask for your comment, please.
Okay, can I just understand the question? So as an academic, having acted in Johannesburg, whether I think I have gained the necessary experience to continue in the High Court?
No, that is it advisable for at least someone to go through the ranks of the High
okay.
Court so
Yes,
that when
I
you do the
understand.
adjudicative
Yes,
work,
okay.
you've got the actual feel
Yes.
of what happens in the
Okay,
court.
now I understand the question. Thank you. So I think I was thinking about this question a lot after the previous round of interviews in April, and we have the 17th constitutional amendment that broadened the jurisdiction of the Constitutional Court to not only be restricted to constitutional matters. So the matters that serve before the Constitutional Court at the moment are really vast. They're not just focusing on, and I have also listened to Commissioner Nkaitoge's questions earlier this week about whether all matters are not constitutional matters, so I'm going to pause that just there. But the point is, it's difficult to be an academic that knows everything that will enable them to go directly to the Constitutional Court, I think. And that is because when you are in academia, you have a very specialized field of law, and you're not exposed to all areas of law. And I think that 17th constitutional amendment of the Constitution made it difficult to find an academic that can go directly from academia into the Constitutional Court without having any court experience whatsoever. I don't think it's impossible, but I think it is very difficult.
Yes.
Because the matters that I'm faced with at the High Court are things that I don't do on an everyday basis in academia. I love it because it's new and it's challenging and I love the law. But I think it would be quite daunting to sit in the Constitutional Court coming out of academia and now having to be faced with matters that I'm not familiar with. But as I said, I don't think it's impossible. I just think it would be very, very difficult.
Yes. If you may comment, would you say it may also apply to practitioners like senior advocates and the others that at least to go through there and have a feel rather than go directly, given the kind of work that you're exposed to and that they may not be exposed to in their practices?
Yes, I think it will depend on the practice of the practitioners. Some practitioners have a broad practice and they practice in everything, and it's again a little bit different than coming from academia where you try and specialize in the field. But I think it will depend on the person. Again, it's not completely impossible, but I think it's difficult. Yes.
Thank you, Prof. Thank you, Chief Justice.
Thank you, JP. Commissioner Pillay. Thank you, Chief Justice. Good morning, Prof. Duplessis.
Good morning, Advocate Pillay.
May I begin by commending you on your judgments.
Thank
They're a
you.
real pleasure to read. They're well-structured, well-reasoned. There is one judgment I do want to raise with you, though.
Yes.
And I'm not sure how to refer to it. It's the ICMGDG matter.
Yes.
The one involving the relocation of
Relocation.
3 children to Belgium.
Yes.
Now, you did something quite unique in that judgment.
Yes.
At the end of it, you included an addendum
Yes.
addressed to the 3 children.
Yes.
Now, when I read the addendum as a mother,
Yes.
I found it so beautiful.
Thank you.
Because I could see what your intention was.
Yes.
But when I reflected on it as a practitioner,
Yes.
a few concerns started developing,
Yes.
and I wanted to raise those with you. Firstly, I was debating with myself whether when you include an addendum to a judgment, what the status of the addendum is. Does it form part of your reasons? And if so, is that where litigants would look for some of the reasons for your judgment? And would that inform then an application for leave to appeal? Just want to get your sense on that.
Yes, thank you. So you will see on my CV, I'm just going to say how I got to do that. I know it's unusual in the South African law context, but on my CV, I wrote a book review on the art and craft of judgment writing by Max Barrett. He's an Irish judge. And I was asked to write the review for the Journal of the South African chapter of International Association of Women Judges. And in that book, he has a whole chapter about this issue of addendums. And that is something that he does quite often, and that happens also in the English courts. For instance, in issues of immigration, where people might not be well versed with English, those type of matters. And the reasoning for attaching the addendum is to explain to the people affected by the judgment why you came to the reasons that you came to, in a way that makes the law accessible. And I think I did it from that perspective. I feel very strongly that law must be accessible to everyone, and also to those 3 children who had to move because of my order. I thought this is a chapter in their lives, and they need to understand how the judge came to that judgment. So what I did is I first wrote the judgment in the normal legal form, and then I just wrote that addendum based on the judgment. So what's in the addendum should also be in the judgment. So I think that then addresses your question, whether those are reasons. If they are reasons, to the extent that they are reasons, it's the same reasons that were given in the judgment.
And if you find in the addendum that you go beyond what is in the judgment, what happens there?
So my understanding again, and now I go back on what was written in I also read academic articles on this issue before I wrote that addendum, I should add, that the addendum does not form part of the judgment. So the status of that is just explanatory. Sometimes people write letters, and obviously that does not form part of the reasons or yes, I think.
And just lastly, in those jurisdictions, was there a particular legal framework which permitted the addenda to judgments?
No,
And I just want to check whether we needed a similar kind of system here. And that would, because if I was a litigant at the receiving end of a judgment and an addendum, and if I wanted to punch holes in the judgment, I would certainly argue that the addendum is part of the judgment and use that as a basis to attack the judgment as well.
Yes, I understand your question. I must say I haven't thoroughly thought about that. I understand from what I've read, as I said, in that book on judgment writing and how to make law accessible to people, that it's merely an explanatory of the judgment to the people who are affected by the judgment. So there's no specific legal framework. I think it's about the personality of the judge and what they seek to achieve with their judgments.
Thank you, Prof. Thank you, CJ.
Just to follow up on Commissioner Pilay's last question, and I ask you this question mindful of the dangers of arguing by way of analogy. Is a document of the nature of this revolutionary addendum any different from a media summary that would be issued by the court to explain the contents of the judgment, as long as it does not stray beyond what is actually contained in the judgment?
Thank you. I think that's a good analogy, except the media summary is written for the media, while this addendum is specifically written for the people who are affected by the outcome of the judgment. But I think as long as you don't stray from what is written in the judgment, it serves as a very good analogy. Thank you.
Well, the media summary is not just for the media, it's meant for the public's consumption ultimately.
Yes, but I mean, to the extent that the audience for that is different.
Yes. No, I take your point. Commissioner Mugaitok, is there a follow-up question?
No, it's a different question, so I'll be happy to wait my turn.
Then you must wait your turn. Commissioner Moiman? Is there a follow-up question, Commissioner Trolley? Okay. Go ahead, Commissioner Moiman.
Thank you. Chief Justice, good morning to yourself and fellow commissioners.
Good morning,
Prof.
Good morning.
Just one question from myself. emanating from your article, Rethinking Public Expropriation.
Yes.
The question that I want to pose is, what is the role of expropriation in a typical post-apartheid transformative South Africa? And the current legislation, Section 25(1) and 2, and the Expropriation Act 63 of 1976. Is it adequate enough to drive that agenda? Thank you, Justice. Thank you, Prof.
Thank you. Can I just get the last sentence? Is it adequate enough to?
Whether is it adequate enough to empower the expropriating authority to expropriate constitutionally?
Yes, thank you. That is, I just have to warn you, that was the topic of my doctorate, and I can speak also the whole day about that, but I won't, so I'm going to answer you hopefully shortly. I think people, no, I'm not going to go that way. So the role of expropriation in the transformation, no, I have to go that way. I think sometimes when people speak about expropriation, there's no clarity where in the land reform process it fits in. And I'm not saying it's true for you, but that's the feeling that I get when one speaks about expropriation. So expropriation is a method to acquire the land, and once the land is acquired, then it is distributed or returned, or whatever the case might be. So in as far as it plays a role in that process, it plays the role in how the land will be acquired, and if that land is acquired, what type of compensation would be paid. And I think that then gets us to Section 25(1) and then the Expropriation Act of 1975. And I understand also there's an expropriation bill in the pipeline. I think the Expropriation Act gives the authorities the power to expropriate, and the conclusion of my doctorate was basically we do need an act that is updated because of the reasons when that expropriation bill, the Expropriation Act, that's the 75 Act, was enacted. Market value compensation was the, now the word, the be all and end all, the word will come, standard of compensation. And of course, now in terms of the Constitution, Section 25(3, the compensation standard is just an equitable compensation. So there's a disjunction there. And then also the issue of public purpose. Public purpose is in the Expropriation Act of 75, and the Constitution speaks of public purpose and public interest, where public interest includes the nation's commitment to land reform. Do I think the 75 Act necessarily stands in the way? No, I don't. But you will need to interpret it in terms of Section 39(2) of the Constitution in light of the Constitution. So you will have to give it a specific interpretation. And I'm not always sure if that is ideal. So that's why I think the expropriation bill that came from 2013, 2015, 2018, and currently I'm not sure about the status of the bill. I haven't checked yesterday. But that bill tries and encompassing all these things, including Section 33 of the Constitution, which is also very important in expropriation, and making sure that it is a just administrative action, that administrative justice is adhered to during the expropriation process. Yes.
Thank you, Prof. I was not only just referring to land, I was referring to constitutional property, which includes right to minerals, limited real rights, aims for unjustified enrichment. So I just needed to allay your fears.
I'm not scared to talk about this. Thank you.
Thank you, CJ.
Commissioner Gotzel?
Chief Justice, can I just follow up on this, and I'll let go of my.
Yes, Commissioner Mangan?
Yes. Good morning, Prof.
Good morning.
Thanks for the beautiful answer in relation to Section 25(3). And I see you have also written an article on the conflation between value and compensation.
Yes.
Applying the principle of equity, is it possible to expropriate and compensate at a zero, at a nil?
Yes. So I think what I've always said is that Section 25(3) of the Constitution says compensation must be just and equitable, taking into account the circumstances of the case. And so it will depend on the circumstances of the case. If it is a case where if you take into account all the interests involved and you do the weighing up process that is required in terms of Section 25, it might be possible that during that weighing up process, the compensation amount might fall on R0 or no, but that will depend on specific facts. So it's difficult to say definitely yes or no, but there's a weighing up process that needs to take place, and in that weighing up process, it might be, and I think the expropriation bill in clause 12 also clarify that by saying there might be instances where null compensation may be paid. So it's all about that weighing up process.
Thank you, Prof. Thank you, Chief Justice.
Commissioner Kotso?
Thank you, Chief Justice, and good morning,
Good morning.
Professor. With reference to news reports recently that in one of Gauteng's courts, if you have a civil claim, you will only be heard in 2028.
Yes.
It was also reported...
29, actually.
29. It was recently reported that legal professionals are at their wits' end over the longest backlog in history, and I quote there. What, in your view, is a judge's role in ensuring the expedience in the administration of justice?
Yes, thank you, Commissioner Godsal. I think, and I'm sure you know how the allocation work in the High Court. You get your role in the beginning of the term, and if you are in the Civil Trials Court, you get allocated civil trials. So I think your first obligation is to make sure that if you are allocated cases, that you see them through if possible. There are fewer delays in the civil trial court than there is in the criminal trial court, but I think for one, when a case is allocated to me and it is possible to keep the case and to see to its end, I do that because I don't see the sense in the parties re-enrolling that matter. So that might be one. Of course, case management comes in as important as well, but often also as judges, when you have a role, say you have a special motion role, and your special motion becomes settled and your week is cleared because you don't have any hearings, what judges then do is they go to the DJP in wherever they sit and to say, I'm available to hear civil cases, and then they get allocated civil matters. And that is something that I've done before, that when my role finished before the end of the week and I didn't have pressing outstanding judgments, but even if I had outstanding judgments, I would still go to the DJP and say, I am open to be allocated with matters. So I think that is the extent of what judges can do. Other than I know Advocate Ali spoke about the appointment of pro bono judges and so on, but that's, I think, a different matter than what I can do if I am a judge in that circumstance.
Thank you.
Thank you.
Commissioner Jozitube?
Thank you, Chief Justice. Good morning, Professor du Plessis.
Good morning, Commissioner.
Like Commissioner Pillay, I must commend you on the lucidity of your judgments.
Thank you.
It's been a pleasure to read some of them.
Thank you.
One of them is a very promising one about challenging property.
Yes.
You remember the judgment?
Yes.
In the context, I think, of
family homes.
Of a family house,
Yes.
juxtaposing customary law and common law property.
Yes.
But let's take the debate forward
Yes.
outside of custom.
Yes.
The problem, of course, is the right to property itself.
Yes.
And the debate was always, well, does the Constitution in fact embed the right to property? in the negative expression in section 25(1? Or is the Constitution really intended to rethink the notion itself of property? Now, 3 of the passages in your judgment point to the problem of private property and the constitutional setting, that property by definition is exclusionary, whereas the Constitution has a more substantive understanding of this idea of the relationship, let's put this, the relationship to property.
Yes.
I want to just get a sense, because I have no doubt of your commitment to the values of the Constitution. You live them, you write about them, you are now about to apply them as a judge. Whether or not you doubt if the Constitution embraces an unbridled form of property, and whether what we can expect from you is actually a challenge to the notion itself.
Thank you very much. I think that's a difficult question, so let me just readjust myself. I think for the first question, whether the Constitution protects the notion of private property, I'm paraphrasing you now, and
Yes.
not very eloquently so. I think if you look at the history of the making of Section 25, you will be well aware that Section 28 of the Constitution mimicked the German Constitution, in that Section 28(1) stated clearly property is guaranteed.
That's the interim constitution.
Yes, that's the interim constitution. And I think it's quite telling that that Section 28(1) did not make it to the final constitution after the deliberations in the Constitutional Assembly. And from what I understand, I've read all the notes on the deliberation of Section 25 in that Constitutional Assembly. That was done on purpose. And if you also read, there's a book by Justice L.B. Sachs, Oliver Tambo's Dream, I think. In there, he spoke about that issue where he said that was deliberately left open not to solidify private property in the Constitution, because that was seen to be a political contestation in a sense. So that's the answer there. But I do understand when people criticize the Constitution by saying, well, Section 25(1) says that the state cannot interfere in, nobody may be deprived of property unless, arbitrarily deprived of property unless in terms of a law of general application. And in that sense, it might be interpreted that it does solidify private property. So I think that answers that question. But I think what is more important is if we think about property in terms of the Constitution, and that's certainly something that I have written about academically. I've recently also written in an eviction case about that. That idea that property can only mean ownership, and that ownership can only mean ownership to the exclusion of everyone else. That is what we are challenged to interrogate under the Constitution. I know Professor André van der Walt wrote this article where he said that notion that we have this hierarchy of rights with ownership at the top and all the other rights at the bottom, it was used by the apartheid government to protect white ownership of land. And what we now need to do is we need to open up that, so that in some instances, right in property that might not be ownership can challenge those notions of ownership. And we already see that in eviction law, for instance. There are some instances where the owner of the land cannot evict somebody who has the right to not be evicted if it's equitable to do so. And that brings in a challenge in the property law sphere. And I think those are the type of instances that one can explore on various fronts. And I think that's what I'm trying to do in some of these judgments, and that's certainly what I did in that family home judgment, where I said there are certain rights in a house. If you have a right in the family house, it should be that in some instances that right should be able to trump the person who is the title deed holder for various reasons. And of course, there's a very fine line that the judge must walk in that regard, because it might be more of a policy or political issue. But I think one can challenge those notions if the facts of the case before you allow for that. And I think, I'm quite excited about that, as you can see.
Yes, no,
Yes.
thank you. No,
Thank
it excited me too because we've lived for 30 years in a
Yes.
straitjacket of the common law of property. And with judges reinforcing
Yes.
the straitjacket. With your judgment, there were other judgments we were debating earlier from Judge Cowen that are beginning to actually open up the space so that the Constitution means something.
Thank
So it's an exciting start. So, but my understanding of your answer is that you will continue to entrench that
I'm glad
vein
it's
of
visible.
thinking.
I'm glad that effort is visible. Thank you.
Yes. Now, the second thing,
Yes.
it's around expropriation.
Yes.
The people talk of market value in an expropriation. Now, I've argued that it is a total fiction
Yes.
because there is no market in an expropriation. There's a state is trying to acquire land for redistribution. Market value itself is also a fiction because it presupposes a willing seller with a willing buyer, and both of them are ignorant as to the real price. But we know that doesn't actually exist. But do you also agree, or do you have a different view about the utility, maybe futility really, of applying market value in expropriations? That was a fundamental mistake committed by the early constitutional court in thinking that market value could be a starting point when it specifically deals with land reform, and whether you think actually land reform should be thought differently than any other forms of property because it's about addressing the original sin, and whether there are constitutional ways that you've thought about that we can actually start to challenge. It's also another straitjacket that has constrained proper land reform.
Yes, again, that was exactly what my doctorate was about. I'm not going to repeat that. And I think the position I held then was, I was also saddened. It was a Du Toit judgment, which was incidentally not a land reform judgment, that said we start with market value. And again, that then places market value at the center of the inquiry. But I have since developed a more nuanced approach because I do understand that when you do come to court and you want to argue about compensation, in the end, the court must give
a number.
Give a number.
Yes.
And
But I mean, Judge Cowen says
Yes.
that's not the case. You don't always have to give a number. And even if you do have to give a number, you can start with current use of the property and try to give a number to that.
Yes, I think where I want to get at is you will see there was a later article on the disjunction between value and compensation.
Yes.
Because it becomes more complicated when you start to ask the question, who's got the authority to make that determination? And you will know from the Malmuth judgment where the OVG said that the Land Claims Commission in that case is bound by her determination. And the Land Claims Commissioner wanted to have some leeway to be able to negotiate. Then that issue of value and compensation comes in. So what I want to say is I've moved a little bit to a more nuanced approach where I said, okay, I understand why you have to give a certain value. It does not have to be market value. We have to have a certain value to work from. And so in my writings, I say that should be the job of the valuers and the OVG. But in doing that job, they must say these are all the factors that we could see on the ground that might influence the decision maker in coming to a compensation amount, because a compensation amount must be just and equitable. And justice and equity, and there I then totally agree with Judge Cohen, and I think you've made similar points, that it's justice and equity that informs compensation. But if you can keep these two things separate to an extent without placing value in the center, but understanding that value needs to form part of all those factors that you take into account by coming to a compensation amount, and that compensation must be just and equitable, so it's justice and equity that inform that amount, then I think we are moving.
So that's also part of the philosophy you are bringing into the system.
Yes, I hope
Well,
so.
both of those answers are excellent and music to my ears. I hope, long may they continue to percolate.
Thank
Are you going to act in the Land Claims Court if
Advocate
invited?
Advocate
Oh, sorry,
Noba,
Chief
I thought
Justice. Yeah.
it is a critical and gripping subject. We acknowledge that, but let's wrap it up. There are 7 other candidates still to be
Yes,
interviewed.
that was
And
just to ask.
I would ask our expert to please keep your answers as concise as
I will
possible.
try. Don't ask me expropriation questions. I've got much to say.
No, it's just to ask her whether, if appointed, she would make herself available to the Land Claims Court.
You may ask that question.
All right. Well, you've heard the question, Professor.
Yes, I'm willing to make myself available to the Land Claims Court. I'm already with my academic hat on, helping with that historical cases project. So I'll be more than willing to continue with that. Thank you.
Okay. Commissioner Trollip?
Thank you, Chief Justice. Professor Duplessis, I'm largely covered by your responses to Advocate Mugaitobi.
Thank you.
When the Chief Justice asked you about your studies, you said something about, you wanted to finish in a hurry because you didn't think they'd be relevant for much longer. Could you just expand briefly on that? And then while you're doing that, could you explain, I understand that the market value concept is outdated. It was relevant to a 1975 Act and all of your responses thereto. Can you explain the difference between market value and current use value and attaching a numerical number to current land use?
Okay. The question about outdated was the market value. Can I just answer just the market value question now and the current use?
You've already answered the market value one,
Yes.
as far as I'm concerned.
Yes, okay.
The new parlance is current use.
Yes.
Can you just explain the difference between the two?
I hope I'm going to remember the nuances, because you've got the expropriation, the Property Valuation Act, and in terms of the Property Valuation Act, there were regulations published that looks at the current use value. And that was the subject in the Moloto judgment that was also spoken about earlier this week with Judge Cohen. And I agree with Judge Cohen in what she wrote there in that judgment. But the problem in that judgment links with the regulations in that it's very technical, so I hope I remember how that current use value is explained in the regulations. But the way that the current use value is set out in the regulations, I'm just going to leave it at that, is problematic. And I think the nuances of all that came out in the Moloto judgment, and I fully agree with Judge Cohen's judgment there. So I think that would be my short answer in the interest of time.
Chief Justice, just to follow up, and your short answer about hurrying up your studies because they wouldn't be relevant for much longer.
Oh, that was. So in 2008, there was an expropriation bill, and I finished my doctorate at the end of 2008, and I was afraid that that bill will be passed before my doctorate is finished, but that bill was then shelved eventually, and then there was 2013, and then for a long time I did not do any research on expropriation because it seemed to be dormant. And then, of course, as we all know, in 2018 that changed. So it's just the nature of academia. You try and contribute with your research. Yes.
Thank you, Chief Justice.
Thank you.
Commissioner Marumagai? Professor? Commissioner Bredenbach? It's not frozen or anything like that, is it? Okay. I'll take that to mean they no longer have need to ask you questions, Professor de Villiers. Was there another hand? What did I call her? Oh my goodness. Maybe. Well, let me not say what I wanted to say. Commissioner Mangia?
A short one. Professor, I see you wrote an article on the meaning of a home in the context of Section 26(3) of the Constitution.
Yes.
And you also wrote a commentary on a SCA judgment of Ngomane versus City of Joburg,
Yes.
the unanimous judgment that was penned by the CJ. And you were critical of the meaning of the word home as defined in the approach that was taken by the SCA. And you would know that subsequently and recently, the SCA, in the case of students, I'm trying to
Yes.
recall, stay at South Point Property versus Mkulwana, a judgment of Judge Antahalter. The CA said that the residents where students stay for the duration of the academic year, it's not a home. And given the fact that you were free to comment as an academic, now that you are going to be a judge, how would you navigate academic freedom with the principle of precedent, stare decisis or stare decisis, whatever they call it?
Thank you. That's a wonderful question. I've asked myself that many times during my acting stints, because now already I was wearing two hats and I had to be careful. I just want to clarify that chapter that I wrote on the meaning of home was in 2015, and it's only later that the Ngomane judgment came out. So I just said that the work that I did in my academia was relevant for us to understand the Constitution, for example, and then I gave that example. So I was not referring to that judgment in my academic work. But I take the point that you say, and it is, of course, a little bit of a mind shift that I have to make when I am an academic. I can engage with judgments critically, and I can express my opinion respectfully. So I hope I've always done that respectfully, to show where there's room for development. But I accept that when I am a judge in the High Court of Johannesburg, that I'm bound by the President, by the judgments of the courts above me. So I did judicial training as well, and that question came up in an exercise that we had to do, and I didn't agree with the reasoning in a constitutional court. I agreed with the outcome, but not with the reasoning. And in that training session, I asked the constitutional court judges, what should I as a high court judge do in instances like that, where I don't fully agree with the reasoning in the constitutional court, and I understand from the answer I'm bound by it. Some constitutional court judges said you can mention it, but you remain bound by it. So I know that there's a nuance, and I know that I will have to, in some instances, make that mind shift, but I think I do so fully aware of what is expected from me. Thank you.
Thank you, Chief Justice.
Thank you, Commissioner Mangen. Professor Du Plessis, there are no more questions for you.
Thank you.
Unless there's anything you wish to raise with us, you may be excused.
Nothing to raise. Thank you very much for the opportunity. Thank you, Commissioners.
I think the questions about the backlog 2029 and whatever can be answered by candidates or by myself as a head of court, but I refrain from raising it with this candidate because the short answer is, Commissioner Gottsel, is judges in the civil trial role are no longer not more than 10 per day. And the allocation there is 50 matters in Pretoria and 20 in Joburg. Naturally,
Good morning, Advocate Lapuskarne.
Good morning, CJ.
How are you?
I'm very well, thank you. And yourself?
I'm fine, thank you. You hold 4 degrees, all which you obtained cum laude.
I must confess the last one was the upper second. That wasn't cum laude, that was in Cambridge. But the
Now
others
I
were
feel
cum laude.
better. Okay. Well, a BCL, a BA honors, an LLB, and the LLM, for which you did not get the honors. Okay. You did articles successfully, but then chose not to join the sidebar.
That's correct.
You started practicing as an advocate in 1988 already,
That's correct.
and you've been at the bar since.
That's correct. So for the year that I went to Cambridge.
Yes. Is that the Johannesburg bar?
No, Pretoria.
Sorry, Pretoria, yes. Okay. You explain in your application form that your practice or your junior practice included matrimonial law, criminal law, labor law, personal injury law, and the spectrum of commercial law, including, and I'll just mention the ones that interest me, banking, insurance, and construction law, and intellectual property law.
That's correct.
And you've done pretty much everything, I take it. And you've also sat in arbitrations.
I appeared in arbitrations and I've sat as the arbitrator as well.
When did you take silk?
2006.
Okay. You mentioned that you also sat as a member of the Labour Appeal Court prior the Labour Relations Act.
That's right, yes.
Was that frequent?
A few times, yes. I was doing quite a lot of labor at that time.
Okay. Well, you are credited for leading the transformation initiative of bringing in Black Junior Counsel into your chambers, and not ending it there, but mentoring many Black junior advocates in Pretoria. Is that so?
That is correct.
Mm-hmm. And you have participated in the pupil training committee as well?
That's correct. Yes.
Okay. You also lectured at the University of Pretoria?
Yes, that was...
That was before, was that before you served articles?
Yes, it was while I was doing my LLB. I was doing a BA Honours in Latin at the same time, and I was a junior lecturer in Latin at that time, when Latin was still a compulsory subject for LLB as well.
Yep. So you've practiced for 36 years?
Yes.
And for how long did you act as a judge? Have you acted as a judge?
Yes, it's 19 weeks.
19 weeks, which is
Yes.
not a long time.
It's almost 5 months, yes.
Yeah. But what kind of work did you do during that? Was it one acting stint or a collection?
No, it was spread over a number of stints, and there is a breakdown which the JP has provided of what I've done. The only aspects which I haven't been involved in as a judge is as in respect of the tax court and also the criminal trials themselves. I've done a few stints in the appeals of criminal matters.
But no criminal trial as yet.
No trial. Yes, as junior counsel, I have appeared in criminal matters representing defendants, but I haven't presided.
Okay. And you claim to have written about 50 judgments during those stints.
That's correct, yes.
Okay. Any of those reported?
Not that I'm aware of. I find most of them on Safely. I haven't checked whether they've been. They're in the law reports that I couldn't do.
And you don't have any reserved judgments?
None.
Okay. All right. I'm going to hand over to Judge President Mlambo to take you through the paces about the rest.
Thank you, CJ.
Thank you very much, Chief Justice. Good morning, Advocate Labuskachne.
Good morning, JP.
Then let's just place on record that you are also here because of discussions between yourself and myself in the last 2 years.
That is correct.
When you raised your hand then that you'd like to become permanent, and then I said to you, I will give you the nod when I think the time is right for you to come and face this body.
That is correct.
Right. My spreadsheet that I've given to the commission misses 5 weeks. You say you've done 19 weeks, and I apologize for that.
Yes. 2006, in the year in which I took Silk, I did 2 weeks, and then again in 2008. There's another 2 weeks.
Those are the two. That's 2. That takes it to 18.
There's a week missing which I can't find.
Okay. Well, 2006, 2008, I was a puny judge, so I don't know what happened then. But anyway, sorry about it.
Yes.
The moral of why I'm asking this is, in my spreadsheet, you've done 3 agent court weeks.
That's correct.
That was in Pretoria.
Yes.
Was it during term or during recess?
They were during term.
So you would have faced the full load of the agent
yes.
allocation.
Yes, I was there at the time when there were only 2 judges.
Yeah. And then, the commission knows the average allocation load in the agent court. And then you've done 2 special motions.
Special motions, yes, I've done 2. That's right.
Yeah. If you think you've done more, you must tell me, because
yes. Well, those were where I was on the roll, the duty roll for that week. I might just mention, JP, that as far as criminal appeals are concerned, the spreadsheet misses 1 term in 2021 and another one in 2023. I've did 2 stints with criminal appeals.
Thank you very much. And then in terms of opposed motions, I've got 3 weeks here.
That's correct, yes.
Yeah. Now, what you said to me when we spoke about your availability, I said, my preference in giving the nod to candidates to avail themselves of judicial appointment is that in the sunset period of your acting, I would like you to do a full term.
Yes.
You remember, and you told me that it would be difficult for you to give me a full term because of your practice.
Yes, I have a very busy practice, and the overheads are such that to be away for 3 months casts a shadow of another 3 months. It's effectively being out of private practice for 6 months. It's just too expensive.
Yeah, but I think what you said, which I think is justified, you said what compensates for not doing a full term is that your practice is predominantly, if not entirely, high court practice.
That's correct, yes.
Right. Thank you very much. And in terms of the judgments you've written, the spreadsheet I have, or the document I have, does not indicate the periods But I think in one of the answers you gave to the CJ is that you give judgments timelessly. But have you given, or let me ask you this, have I ever confronted you about reserve judgment?
No, JP, my judgments are done by the time my acting stint is over.
I see. So all of them within 3 months?
Yes.
You've never had occasion to go beyond 3 months?
Well, a few days perhaps afterwards, if applications for leave to appeal would come in, that I would hear later, yes. But I've made a point of being prompt.
The judgments themselves?
The judgments are finalized.
Within 3 months. I know there's one leave to appeal that you did when you were somewhere in the US. Was it the US or
That was correct, yes. It's the first matter I was referring to. It's the United States Polo Association. It was a fight between trademark competitors, and the one was contending that the other's goods in the harbor are counterfeit.
Yeah.
And 3 judgments flowed from that. One on the merits, a leave to appeal, and also a Section 18(3) application. That's the one on which I was overturned in an automatic appeal.
Yeah, and that's the beauty of virtual hearings and case lines.
That's correct, yes.
Thank you. Well, yesterday, Durban Council was singing the praises of case lines. I wonder why Gauteng Council are so muted about the system, because it kept their bank balances okay during COVID, you know.
Yes, case lines is a lifesaver. I would advocate its rollout countrywide.
Yeah. So it may sound repetitive and annoying to some commissioners, but I have a scoring matrix.
Yes.
In terms of how I score candidates. One of them is how the interview itself goes, but in terms of your exposure to complex work, like the special motions, the opposed motions, as well as the urgent court.
Yes.
Right? As well as how you handle the work and turn around in terms of judgments.
Yes.
I've weighted that one heavily. It's got a scoring of 7.
Yes.
How much would you score yourself?
JP, it's a subjective thing. I think I did well.
You think, okay, that's fine.
I would certainly not go less than what you've suggested. I might suggest more. But that's me, my objective opinion. Oh, I'm just joking.
Okay.
No.
Thank you very much.
No.
Thank you, CJ. No further questions.
Thanks, JP. Premier?
Thanks so much, Chief Justice. Good morning, Advocate.
Good morning,
Babas
Premier.
Karni. You responded in the positive when Chief Justice said you are a champion of transformation in some of the legal work that you've done. I need to get outside that if we have ever promoted any form of transformation and where outside your workspace.
Outside of the?
Workspace.
Look, I've been involved in as a pro bono advisor to indigent people in the city centre for more than 10 years on a regular basis. That was aimed at assisting people who can't afford legal help, who are destitute and desperate. So I was involved in that for many years. Was also involved in training. I helped the asset forfeiture unit to get their advocates ready for court appearances and to teach them courtcraft in advancing their own applications. And as far as training is concerned, it's something that I enjoy. And whenever I've worked with juniors and young advocates, not even where they are my juniors, even where they just ask advice, I'm known to have an open door policy, and there's a steady stream of youngsters who tap into my experience and my willingness to assist. And many, if not most of them, are black.
No, thank you. In the questionnaire for candidates, you proudly stipulate that the DA was your client to secure the release of the former public protector's report. But you further indicate that you represented a formation that you don't declare in the diplomatic immunity case against Ms. Grace Mugabe. Why you are proud to declare the representation of your client in the form of the DA, but on the Grace Mugabe case, you are not declaring who's your client?
Yes. Could I just correct? When I state that I acted for the DA, it's because they instructed me. I'm not doing so as a matter of any pride. I was sitting right next to Advocate Nguka Tobe, who was representing the EFF in the same application. I think we had the same vantage point, and we were arguing the same issues. That was an interesting case where, for once, there was a unity amongst political parties who seemed to be at loggerheads on everything else. So that was an occasion when there was an alignment as far as legal approach was concerned. I happened to have been instructed by the DA. As far as the matter of Grace Mugabe was concerned, the case is cited as the DA. There were actually two applications. I was in a separate application representing the complainant, Ms. Engels, and also AfriForum, who brought a similar application. They were heard at the same time. But you will not see it in the citation. That's only for that reason that I didn't think it's necessary to.
So your client was AfriForum?
AfriForum and Ms. Engels, who was the complainant in the criminal case.
So why didn't you state it that your client is AfriForum, but when you're representing a DA, you proudly stated that you're representing the DA?
Yes, no, there's nothing sinister about that, Premier, and I've already addressed the issue whether I cited proudly or not.
Thanks.
Commissioner Hassan?
Thank you very much, CJ. Over here, Advocate. I have two questions. I'll start with the first, relating to the UDM versus ESCOM case. And let me caveat and begin by saying, I think there's general agreement from all sides of the table that load shedding is prejudicial to the country, of course, to specific sectors of public institutions, etc. I think we're all in agreement with that. That's not where my question is situated in. I think my concern, and maybe I should also say this, CJ, that I am also on the portfolio committee for electricity and energy. Yes. So very much involved with the NERSA issues and upcoming electricity tariffs, and perhaps maybe, let me say, very passionate about how we bring about equitable access to electricity. CJ, my question relates to the separation of powers and to, I think, very difficult legal jurisprudence that has been developing over the last few years. And while we can agree there was a need for intervention on this particular matter, I am a little bit concerned by judgments that are handed down that are frankly impossible for the state to implement. And let me explain or expatiate a little bit. We agree that police stations, schools, hospitals, etc., should not be load shed. I don't think there's anyone who disagrees with that. Yes. But the way the grid is designed, we can't just not load shed one particular corner of a street, right? The way the grid is designed is not that. Yes. And for us to literally redesign the grid would cost us trillions of rands that we do not have in the fiscus. And yes, there's an argument to be made that we're now developing transmission, etc. But I do think that and I've read the case before coming here today. So I'm trying to separate a constitutional issue with the practicality of what is possible and is not possible. And where do we get to a point where we are handing out judgments or handing down judgments for legal jurisprudence sake vis-a-vis the actual protection of the people we're trying to look after? And I'll say this by saying, if the grid collapses, and there is a blackout in this country, forget schools and police stations, you have civil unrest. And those were the kinds of contentions that we, and let me not say I was not there, I was in the legislature, but that were having to be balanced out. And I do wonder, Advocate, whether those considerations played a part. And I'll say it openly, I do wonder when there is a need to overstep the separation of powers. We agree there is sometimes a need, but then the immediate pulling back. So you overstep to make a decision, yes, understandable, but then make a decision that is impossible to implement. And then again, we want to talk separation of powers. Then it's the executive that must implement a court order that is impossible to implement. So I'm just interested in the comments, CJ, and then I'll ask my second question. Thank you.
Yes. I think yes, I know which judgment you're referring to. I think one must bear in mind that if there was an overstepping of the mark by the court in granting an interdict of that nature, that there is an appellate process where corrective measures could be taken by the higher structures in assessing the reasoning of the court or quo. I'm not aware whether that matter has gone that route or not. When it comes to separation of powers, it's obviously an important consideration to ensure that there isn't judicial overreach. That does of necessity require a weighing of interests. When it comes to formulating a remedy, however, it must, I think, in principle, be capable of execution. And if it does overstep the mark, it must meet the test of being an exceptional circumstance as set out in OUTA. It cannot be a knee-jerk position to assume. It would really be exceptional. Now, I think as far as load shedding is concerned, it's been a bane of our existence for much too long. There are judgments about it, I think, in 2013 already. And the fact that it has been around for so long is really a matter of great disappointment to everybody. The solution to that, unfortunately, doesn't lie in the courts. And I think that's where courts have been trying to, I think that same judgment says the courts cannot solve load shedding. But when it comes to prioritizing who gets electricity, I think the court in that instance tried to take a position. Whether it's possible of execution, I don't know whether that was properly before the court. In the matter in which I was involved in, which was one of the related applications, we were really advancing the position of public participation in determining the allowable revenue of Eskom. And where our position was really that when NERSA itself would report 6 months before that there were billions of rands of misappropriation within Eskom, and now has to determine allowable revenue, is it a valid question to ask whether they should be put into place precautionary measures to avoid the public purse being deprived of the benefit of public contributions? So that was a vantage point, which I think it's still to be crystallized, but our vantage point was to have the public be heard on these important issues prior to NERSA determining an allowable revenue.
Thank you, CJ. My second question, and maybe just to say that before, one of the reasons why we've put a stop or been able to put a stop to load shedding, different to load reduction, is actually, maybe it is important to say, not because of the rulings of that particular case I cited, is fundamentally because of the ingenuity of Minister Ramokgopa and the team. And why I'm saying that is it could be conflated that the issue of load shedding now is different because of the case. But CJ, my second question relates to, and I'm looking for it here, because as you can see, I have a lot of documents to try and find it. But just to be clear, Advocate Labuschagne, did you act in any cases involving the University of Pretoria and fees must fall activists or students?
Yes, I was involved on behalf of the University of Pretoria over many years, and the fees must fall campaign was part of it. Yes, that's
Thank
correct.
you, thank you, Advocate. Let me also caveat the next question by saying, which we all know, I was a foremost leader of Fees Must Fall at Wits University, a different institution, but the question is important nonetheless. Advocate, what are your views on the bullying tactics, not only by universities using top legal counsel to bully arguably a very marginalized group of people, students, who were exercising a very legitimate right to protest in view or really in finding the objective of free quality decolonized education. And I say that fundamentally because when you're a student, you have nothing. You have no money, and I'm very interested, Prof. Mr. Mangena also raised this around student housing earlier. You don't have much to leverage off with. In fact, the only thing you have to leverage off with is your potential to graduate and contribute to the economy. And I will also say that we had no money to find any sort of legal counsel. And when universities came to us, and I'll tell you an important moment during Fees Must Fall, there was a legal counsel who came to me while protesting. It's got nothing to do with you, Advocate. I'm just trying to give context. Who pointed at me and a number of other students and said, "This is the end of your legal career. We will prosecute and we will move to the very end." And there are many instances of student activists and student leaders, Kanya Eshe being one of them, Bonginkosi Kanyile, and many others who have lost every opportunity given to them because of some of the cases that emanated from those initial days. So I'm just interested, Advocate, in your thoughts around the bullying tactics of universities and council who also seek to bully the most marginalized of society.
Okay, could I address that issue from two vantage points? The first would be that in formulating applications on behalf of a university that is facing paralysis as far as lecturing is concerned and a threat to the exam program being completed, the formulation of the application and the relief sought took very careful notice of the right to protest. It's an acknowledgement. With a legitimate gripe, you have a right to protest. The question is, however, how do you exercise that right? And there, unfortunately, there were instances of criminality. There were instances, if you speak of bullying, of people walking in and hijacking classes where people were about to write their exams. Now, that type of conduct, although it makes a point, also oversteps the rights of other students to be educated. They have, after all, paid for it. So the right to protest is a right that needs to be exercised within the law. And the purpose of those applications was to ensure that that right is exercised in a way that doesn't paralyze the university, but doesn't limit their right to express whatever position they want to advance. So there was a balance involved. And I certainly don't see my own involvement as a matter of bullying. I think we were quite sensitive to the rights of students, and we were trying to balance the rights of other students and of the university to discharge its obligation of training students and affording them an opportunity to write their final exams.
I realize that I may have done you a disservice and sold you short. When you responded to my question about your acting stint that you had acted for 19 weeks, you'll recall the comment I made that that's a particularly long period of time. But then you have a vast CV, which I did not canvass. There are many aspects of it that I did not canvass with you when we spoke. And that includes features such as that in your 36 years in practice, you regularly appeared in our courts, especially the Supreme Court of Appeal and the Constitutional Court. Those are your stomping grounds.
That is correct.
And you've appeared in other courts across the borders as well. on commercial matters.
That is
And
correct.
your arbitration work actually straddles continents. You've worked in countries such as China, in Asia, and Europe.
That is correct.
And you are also a published author
That is
with a knack for writing children's books.
I write children's books.
And a painter.
That is correct.
And a
I
marriage
illustrate them.
officer. All right. Oh, I did not see that hand. JP Tlalezi?
Yeah, just one aspect here, Mr. Labuskachne.
Yes, Commissioner.
Yes, I do not know whether you have attended any of the seminars or training under the auspices of SAJE, but practice has over the years has shown that counsel who come onto the bench with such vast experience do not participate at these seminars. Most of the time is that I don't think there's anything that can I still be taught at this stage, and it's normally being done during recess, and they see their recess period being more valuable to themselves and not attending this training. And one advantage of attending these trainings is that you are able to share your best practices and experience with other colleagues who are participating or attending and not necessarily being taught. Now, I'm not sure whether will you be amenable, if appointed, that you will also make a contribution by participating and also subjecting yourself to be trained in the judicial sphere. Thank you.
Commissioner, I've always been a team player, and during my acting stints in the division in which I acted, there are about once a week there are lectures for judges during lunchtime to bring them up to speed, and I attended those during my acting stints and found them very valuable. I have no reason to doubt that if offered an opportunity to attend these type of training sessions, I will first of all make myself available to be trained. I'm not above that, and I would, in time, if my skill set is recognized, I would be able to assist when asked.
Thank you, CJ.
Thank you, JP. Hands are suddenly coming up now. Commissioner Muiman.
Thank you, CJ. CJ, just one question from my side on the greetings to yourself, advocate.
Sorry, what must I do?
I was just greeting.
Good day to you, Commissioner.
Thank you, Advocate Labuskachne. Just one question that I wanted to pose to you in relation to SAM versus Minister of Copta and Salga.
Yes.
The limitation clause.
Yes.
And the freedom to associate.
Yes.
Because I believe this was at the center of that judgment. The Municipal Systems Act was set aside on the basis of the fact that it contravenes the right to associate, and it limits the political rights of a municipal official.
Yes.
Yes.
That matter was argued about 2 weeks ago in the Constitutional Court, and we are awaiting judgment.
Okay.
So it went further. At the time of my application, the judgment had been granted, declaring that Section 71B unconstitutional. The impact of that section is that it precludes staff members of any municipality from holding political office. And that it is that aspect of their Section 19 rights which is limited, and the argument was, can it be justified? I can go into what the counter arguments were, but the Constitutional Court will tell us in due course what the right answer is.
I'm interested in the counter arguments because there's no right that is absolute.
There's
There's no right that is absolute.
That is correct, yes.
Yeah, because you can imagine a municipal manager who's at the same time a regional chairperson of a particular organization, the influence that you will have over the same political office bearers that must exercise oversight over him.
There is a risk of paralysis of a municipality due to political infighting. And the purpose of that act was to depoliticize local government and to professionalize local government positions. The counter argument was that it was a sledgehammer approach to holding political office. Whereas the argument in the Constitutional Court was that there's a balancing to take place. There are a few members who hold political office, and what one does by proscribing it is to remove the prospect of manipulation of the superior position they hold as against municipal managers and councillors in a manner that disrupts functioning, because that in the end affects service delivery. And we know that service delivery is a very emotive matter which can easily escalate into violence. So the argument was that for purposes, although it's a small limitation of rights, nevertheless of a right that is significant and what was won, it was hardly fought for. But the countervailing argument was that you get millions who benefit through better service delivery if the municipality is not paralyzed by infighting.
Thank you, Advocate. Thank you, CJ.
Commissioner Mkaito?
Thank you, Chief Justice. Good morning, Mr. Labuskaghni.
Good morning, Commissioner.
I just want to confirm that you and I have been on the same side and also on opposing sides.
That's correct. You want to talk about the last one?
Yes, I know. But just a general point on the discussion with the Premier.
Yes.
I mean, there are times when an advocate gets too close to the client and they lose objectivity, which is harmful to both the advocate and the client.
Yes.
But that's not the general rule. The general rule is that you are not the spokesperson of your client. You are its advocate.
That's correct.
And you are detached from the client.
That
And
is-
if you've acted for the DA before or acted for AfriForum before, that's just part of who you are as an advocate.
Well, I might indicate that I've acted for premiers in the past as well.
Thank you.
Was that all, Commissioner?
Yes, it was all.
Sorry, CJ.
Yes, Premier?
I think Advocate Mugantobi got me wrong. I'm not questioning who Advocate Labuskaghni was representing. I was just asking disclosure. That's the only area. That in another part it was disclosed, but on the other side it was not disclosed. Representativity, I understand that fully. I just felt let me clarify that.
Yes, well, perhaps then I should make a different follow-up. Was there any specific reason for mentioning the DA? I'm not sure if you didn't mention AfriForum, but so
I thought the candidate answered the question. He said there was nothing sinister about his intentions. I'm not sure what.
no, then I'm
further
happy
will
then if
achieve.
that is where it ended.
Yes.
Commissioner Pillay?
As a follow-up,
Yes,
to that,
Commissioner Ngonyen.
I was tempted to ask. Good morning.
Good morning, Commissioner.
Advocate. As a follow-up to those questions, I was just tempted to ask you: do you belong to any political party?
I don't. I don't, and I never have.
Commissioner Pillay?
Thank you, Chief Justice. Good morning, Mr. Labuskaghni.
Good morning, Commissioner.
Mr. Mullins wrote a very interesting letter. We won't deal with much of the contents. There's one issue I do want to raise with you.
Please.
And you know that I represent the profession.
Yes.
And some of the feedback we've got from members of the profession, particularly in Pretoria, is that we should probe the commitment to transformation criterion.
Yes.
I see that Mr. Mullins says that his office is down the passage from yours, and he sees that majority of your juniors are black.
That's correct.
Do you confirm that?
Yes, yeah.
And these juniors are being used in matters of substance, etc.?
Very much so. I've had the wonderful opportunity of introducing some of them to attorneys, very large firms, and they are being briefed on their own because they've turned out to be brilliant and they're doing well, and that gives me great joy.
And there would be no reason to your mind, Advocate Labuskaghni, that there should be a concern about commitment to transformation?
Oh, no. I've done that for many years without any hope of being recognized for it. I do it because I believe it's important.
Thank you, Chief Justice.
Thank you, Commissioner Pillay. I've not seen any hands from the virtual platform. Any questions from there?
Thank you very much, CJ. Can you hear me?
Yes, we can, Commissioner Marumachai.
Yes. On the last occasion, I struggled. I think I was not audible. But anyway, good morning, Advocate Labuskaghni.
Good morning, Commissioner.
I see that on your questionnaire, you say that most of your work is on administrative law and by extension constitutional law.
Lately, yes, that's correct.
Yes. I just want to ask you a question that to some seems to be very clear, that our administrative law and in particular administrative action jurisprudence has developed to such an extent that we can say we now know when PAJA is applicable and when it is not applicable. But when one reads most of the judgments that are coming up, there seems to be some inconsistency on this too. I just want to get your view with regards to the development of the jurisprudence thus far. And what I think it's a triangle between PAJA, the Constitution, and then the principle of legality. In your own view, where are we as a country from a jurisprudential point of view in relation to judicial review? Do you believe that it is clear, when you are having an issue, want to review a particular administrative action, you can go one way or the other, or do we still have some challenges in terms of the clarity of the jurisprudence? Thank you, CJ.
Commissioner, if I might just deal with it from what I think is a watershed judgment, was the Gijima judgment. And in terms thereof, organs of state do not utilize PAJA for purposes of self-reviews. It is done in terms of legality. That has clarified the position as far as most organs of state are concerned. So it's a legality test. You don't have to go through all the requirements, time-wise, etc., as far as PAJA is concerned. In the field of administrative law, the development of the jurisprudence under PAJA and under Section 1C of the Constitution, the rule of law provision, has been one of the immensely interesting things. It's almost like two parallel systems, but each one has its function, and I think that Gijima judgment has indicated which one applies where.
No, thank you very much, Advocate Labuskaghni. Thank you very much, CJ.
Thank you, Commissioner. Commissioner Notius?
Yeah. Good morning, Advocate.
Good morning, Commissioner.
Look, I just want to ask you, because as a High Court judge, you will often preside over criminal cases.
Yes.
Just can you tell me, in the application of minimum sentences,
Yes.
what are the limitations of the sentencing court, if any limitations?
Yes, this is obviously an issue which would arise in the conducting of a criminal trial where the issue arises from the charges and a conviction. I've indicated that I've not presided over a criminal trial of that nature. However, as far as minimum sentences are concerned, there is always a tension between whether it is appropriate to apply it in a certain instance and whether there are considerations as to why there are mitigating considerations. And that's very much a factual consideration. The determination of whether the minimum sentence is applicable will be applied or not is dependent on a factual assessment of whether there is sufficient reason to deviate, as will be provided for in the section providing for the minimum sentence.
Is it not that the court must move on the basis that the Parliament has prescribed a sentence, that is, has ordained a sentence which must be imposed, and then you undergo the second part?
Obviously, the default position would be that a conviction attracts the minimum sentence. That would be so. It is a matter of legislative implementing the legislation. You are correct. Question whether it is appropriate in those circumstances is, however, part of the judicial function, because we must bear in mind that as judges, we are administering justice, and assessing the facts would be part of considering whether it is appropriate or not.
Yeah, I'm not sure about that part, but let's move. The second question relates to customary law.
Yes.
Is it competent for a court in the adjudication of a customary law dispute to invoke the principles of common law? That is, we are adjudicating a matter of concerning customary law. Is it appropriate to invoke the principles of common law in deciding that matter?
I think that the answer will lie in the provisions of Section 39 of the Constitution, which determines that when you are interpreting either common law or the customary law or statute, and there are separate areas, you have to apply the spirit, and the purport, and the object of the Constitution. So I think when it comes to determining an interpretation of of customary law, one does it through the prism of the Constitution. I think it would, in principle, be incorrect to step over into the next body of law when it's not applicable, when it is a matter of customary law which needs to be determined and applied. I don't think common law, as a first comment, would find application unless there are compelling reasons. But in principle, it sounds to me that you are mixing apples and pears. You've been asked to decide a customary law issue, so do it.
Sorry, Chief Justice, can I just get clarity? I'm not sure, Mr. Labuskagh, if I got it right. You're saying it's permissible or it's not permissible?
My vantage point was that if you are busy dealing with a customary law issue, it must be accorded the full value that the Constitution accords to it.
You've answered me. Thank you.
Yes.
Right. Well, it seems we've exhausted our questions, Advocate Labuskagh. Unless, is there anything you wish to raise with us?
No, thank you.
All right. Well, thank you so much for making yourself available for this vacancy. And I have to make this comment that it's rare for our top lawyers, which you are, that's a fact, to make themselves available for the bench. And we know what the challenges are. So we always appreciate it when someone like you does make themselves available. And we hope this will encourage, I hope they are listening out there. It will encourage our top lawyers, especially the black ones, make themselves available for the bench. We know the pay is poor, but we are drowning. We need our good people. Thank you,
Thank you for
Advocate.
the opportunity. Thank you, CJ. Thank you, Commissioners.
We've been